Good afternoon, one and all who are there for the administrative law lecture today. Okay, so it's a very warm welcome from my side. I am Professor Akash Chatterjee and from India. Previously, I have taken constitutional law lecture with you guys, and I have received good feedback from you all. Thank you. Would be expecting another feedback this time as well. Without any further loss of time and without any further detailed discussions on allied topics, let us begin our class for administrative law today. First of all, we are really sorry that this class has to be put on schedule, and it's a recorded lecture which we are providing it to you. It was not a live class, but students, whoever is listening to this, I am always available in the ALSA mentorship group. You guys can reach out to me on ALSA mentorship group where I am available 24/7. Of course, excuse the time zones, but you can post a query there. I'll get back to you in my time. Okay. So administrative law, it's quite a hefty course, I must say, but we will try to cover the main things which you would require for your examination. And at the same time, we would try to give you a very sound knowledge and understanding of how and what is this particular administrative law, why is it so important that we study administrative law, and the rest. Okay. Let's start. Administrative law. Now, what is administration per se? If we are supposed to sort of develop what is administrative law. It is a law governing the procedure of administration in any particular setup. Law governing the procedure of administration in any particular setup. Now tell me, when I am, talking about, or when I'm discussing about this particular administrative being or an organization which is considered to be an administrative unit, what do you think? Should it be a private law or a private branch of law, or should it be a public law? Well, obviously it has to be public law because it involves interaction of many people with one another. It is a huge interactive interface whereby we find people engaging with one another within the ambits of an organization or within the ambits of an administrative unit per se. Is it clear? Okay. Now let's move on. Administrative law is a branch of law that controls the actions of government agencies in the executive branch. Administrative law deals with executive branch rulemaking, which is commonly referred to as regulations, adjudication, and law enforcement. Administrative law is a subcategory of public law. Now, what are rules, regulations, principles, bylaws, channels per se in an organization? Consider yourself to be a part of an organization, ALSA, as you all are. You all are students of our ALSA. We all always want to do what's best for you. And being a part of ALSA, or rather being a sub-part of ALSA, what do you think is important? The main principle which governs all relations within a particular organization is reciprocity. If someone expects us to deliver a work on time, the employee expects a remuneration on time. Can you figure out a relationship? A superior expects the junior to work. Junior expects superior to guide. So it is a constant, I would say, a consistent reciprocity which goes on in any administrative unit or in any organization. And governing the relations of this organization, we have industrial law, we have employment law, we have business law, we have administrative law. So students, you would definitely ask me, or you would have this doubt in your mind that why is administrative law so differently studied? You have had corporate law lectures, you have had business law lectures, you will be having business law lecture with me, where I'll be only dealing about the business intricacies of an organization, sorry. So why is administrative law so important to be studied differently? Why is this extra added emphasis which is given on administrative law? This is because you remember when we had this class on constitution, I went about with this particular discussion on rule of law, that even when there is no particular rule specified, even when there is no particular statute codified, there is but the rule of law, the expectation of things to take a definite momentum with the help of a legality. And that legality is administrative law. It is that particular standard on which organizational efficiency, equity can go on. There has to be certain amount of balance. An organization would collapse without that. Okay, so let's move on. A branch of public law is public administrative law and all I have discussed. Why would you be studying at administrative law? This is something I want you guys to know after I have completed the course. I want you guys, this will be my first assignment to you guys as well. Okay, so moving on. Now, the very first thing which we will start discussing is what are departments and how a department functions with the help of administrative law. For example, let us take a department, Department of Labor, DOL, or the Federal Communications Commission, FCC. These are departments with a huge variety of, what should I say, a huge variety of reciprocity of relationships. While there is labor, there is controlling mechanism on the labor. While on one hand, there are superiors and inferiors or juniors in a particular organizational hierarchy, there are definitely set squadrons, there are definitely set standards from where we have to, a set standard of knowing the work, a set standard of realizing the work. So these departments solely run on administrative principles. What are these principles? Fairness, equity. Okay. Then we have this thing. We have fairness, equity, rule of law. We have something called reasonable expectations. We have contractual obligations. Everything binds an organization and administration. Administrative law must be formed or updated to guide operations with time to time. Why do you know? Because every organization is a product of time. It's the need and demands of time. It's the circumstantial application of time that gives birth to administrative legal principles. Clear? Now, guys, the first part of the study is about growth of administrative law. Before much further ado, the growth of administrative law, I will very specifically come to this. The growth of administrative law. The growth of administrative law has been, I am going a bit slow, guys, for this part. You all can make short notes while you are viewing this lecture. This will help you. Growth of administrative law has a cutting emphasis from historical developments in England, where we found Dicey criticizing the concept, giving out rule of law, where we find in 1929, the Donoughmore Committee advised that subordinated legislation be adequately published and controlled. We find growth of legislations. We find the case of Breen versus Amalgamated Engineering, where United Kingdom's first administrative law was established. This is for your notes. But there is something even more interesting. How many of you have come across the name of Henry VIII, King Henry VIII? Oh yes, those reactions are genuine. I know. Many of you are quite raising your eyebrows. That is because King Henry VIII was a very famous slash a character with shades, controversial character. It was in Henry VIII's time that delegated legislation started to be rolling out. Huge amount of delegated legislations were given out. Let's not go into the deep history of his time, but just keep in mind that it was during his time that delegated legislations were given out. Now, what is a delegated legislation? Why did Donoughmore Committee of UK 1929 not support that? We'll come to everything, but one by one. Okay, let's start. Distinctions between public administration and private action. This is the first thing. It is, see, both public and private are different branches of law. But take an example, something which affects you in person, in personam, INPERSONAM, in personam, something which affects you in personam is your private, something which affects you and not only you, everyone in rem, that is what I call a public effect in rem. Okay, large amount of people get affected. Non-payment of taxes. Students, guess. I need you to guess, students. Non-payment of taxes, right? Public. A contractual obligation between two persons for carrying on a work, Mr. A and Mr. B, in personam, right? It's good. Now let's move on. A contrast also exists between a command issued by legislation and in a specific manner failure to comply with it. Okay. So why is administrative law so important in studying public administration? Now let's talk about public administration. You guys belong to different countries. You have seen micro and macro levels of administration going on. COVID periods of time have been exceptionally, I should say, exceptionally glaring in sort of recognizing what kind of action is going on, what is done, what is not to be done. So what is public administration? When a whole number of people get involved in administering a particular thing, it is like you have to obedience, obligation comes to this process. But this entire public administration involves executive action. When there was a curfew imposed due to lockdowns, there were police officials. So that was executive, police officials. Okay. Like you have the law needs to be followed, the law needs to be promulgated, propagated, given out to the citizens. They should be made aware of the law because ignorantia non excusat. Ignorance of law can never be an excuse. Okay. Next, we move on. Given that many issues are too technical, detailed, subject to frequent change to be included in the main body of legislation, legislation being more difficult to change than regulation. This may be regarded as either part of normal process or unavoidable feature of modern government. Why? Why is administrative law an unavoidable feature of modern government? Students, I would really request you, please keep your pens and notebooks, your notepads ready, because while I'm taking the class, I am giving out the questions which will be coming in your examination. Okay, so just one lecture will be enough if you guys can pay attention. If you don't pay attention, even the entire module that has been prescribed to you by Charles sir won't suffice. You need attention in this class, students. Please gather yourselves up. Okay, let's come back. So we have the rise of bureaucracy, we have specialization in governments, we have different departmentalization, we have added hierarchies. It's not that just the ruler is giving commands, and it's not a medieval Europe, it's not a medieval world where there is one ruler, there is a council of ministers. It's a huge administration which goes on in our countries, right? If, take for example, ALSA, you have so many people in charge of so many different activities. You have your course director, you have Lord Atkin, you have Lord Charles. They are all a part of this administrative process. So that's how a modern government functions. People who are specialized in their own areas are entrusted with those responsibilities which they can perform to perfection. And such responsibilities are coordinated with one another and placed in a fixed scale of hierarchy with the help of administrative law. So administrative law is a rule of operating procedure. Write down. Students, I'm going slow. Administrative law is a rule of operative procedure by which public administration and modern governments process. Now, everyone, tell me, what is judicial review? And why do you think judicial review is so important? Anyone? Okay. So judicial review is a system by which existing laws, regulations, rules, bylaws, notifications, legislations, delegated legislations, everything can be brought to a purview, a review, a judicial scrutiny by a judicial mind. Write it down. Judicial scrutiny by a judicial mind. Judicial discretion in legislative intent. Legislation is making the laws, promulgating them, making it applicable on people. But what if the law is wrong? What if the regulation is wrong? What if it does not suit the needs of the people? Who is going to take care of that? Yes, it's judiciary. You know, 3 wings of administration class I taught you in Constitution: executive, legislative, judiciary. Repeat with me: executive, legislative, judiciary. In my constitutional law class, I had taken a quiz. Now, guys, while you are going through this lecture, please keep it in your mind: police, executive; prime minister, legislature; Supreme Court justice, judiciary. Okay. Whenever you view any public officer, in maximum cases, they are executives because they are in charge of carrying on the government administration. Whenever you see a court officer, they are judiciary because they are applying their judicial mind. And who is drafting the law? Your parliament, your government. It's legislative or legislature. Okay. Judicial review is equally important because at the end of the day, Dicey's rule of law is that one benchmark on which the entire process goes on. Rule of law, write it down, please. Rule of law is that fundamental sacrosanct principle on which the entire process of legislation, policy making thrives. It is an indispensable part of legal regulatory mechanisms. Nothing can escape judicial review. The findings of a court or tribunal are effects of a judicial mind which cannot be escaped or forsaken. Okay. Now, common law system, you know, common law system. Chief Justice Sir Edward Coke had observed lions, but still lions beneath the throne. Okay. Common law system we find in UK, we find in India, we find in United States. This is that system which heavily relies upon judge-made decisions, the decisions of a court. While there have been different modifications in the common law system, but it is still heavily dependent on what the court decides. It can be an adversarial system, like where the judge is neutral, 2 parties argue their sides and a decision is sought at, or it can be an inquisitorial system, whereby the judge actively takes parts in the investigation. Students, you should refer to the courts of United States to know about inquisitorial system. You should refer to courts of India and United Kingdom, as well as in many of your own countries, to see what is adversarial system. So this is all about common law system. Common law system entails a separation of powers. Okay. And with there is a recent trend about tribunals. Different subjects have their own dedicated tribunals. These tribunals serve those purposes. Such a glaring trend has been noticed in Australia. Students, what is a tribunal then? Is it executive or is it judiciary? Right, it is judiciary because judicial mind. Now, this was all about the common law system. In one sentence, let's recap. Common law system is a system in which judgment laws become the rule of the country. What is a council of state system? It's about the French system. Council d'État, where you have a certain number of people. For example, we had in case of Napoleon, Council du Roi, then Council d'État. Okay. These are councils. These are congregations of people. Declaration of Rights of Man and Citizen in France made separation of powers a priority. And in council system, you will remember this thing, that in case of a council system, the main argument is that if a court is viewing or reviewing or scrutinizing, if a court is viewing, reviewing, scrutinizing a legislation, then where is the separation of powers? In administrative issues, Council d'État is the final authority. Former prefectural councils, which acted as administrative courts, subservient to Council d'État, were changed to administrative tribunals. Tribunals, the conflict decides whether a case is within administrative or ordinary court jurisdiction, whether there is a question. This is a special court comprised of 5 judges. Several other countries have followed France's lead, including state councils of Italy, Greece, Belgium, Turkey. So what we found in common law system was a particular court system where everything comes to judicial purview, preview, whatever you say it. But in French evolution, we find a strong separation of powers with a, write it, principally, fundamentally empowered council. Power rests with them. Next, we have the procurator system of Russia. Procuracy, system for assuring administrative legality. 1772 by Peter the Great, who was the eye of the Tsar. 1764, Catherine II raised a decree. Now, let's think about this procurator system of Russia. Okay, let's think about this system. Procuracy. Although the entire system organized huge change with being a watchdog for legality to ensuring regulations issued by ministry, they were also opposed to ensure that officials didn't follow the law to the letter. The entire procuracy was sort of a vigilante. How many of you here are fans of superhero fictions where you find a particular superhero being a vigilante? A vigilant. Okay, that means a person who exercises close vigil. What is vigil? It is a supervision with a moderation. Okay, it is something which is a supervision and a moderation. And this vigilante system is only in procuracy of Russia, where ministers, ministerial portfolios, ministerial words, actions, everything gets judged with gets judged with procuracy. Okay, let's move on. Ombudsman. Before starting with Ombudsman class, let's take a 2 minutes break. Okay, class. Let's start with Ombudsman now. Ombudsman is an element of administrative law system tasked with analyzing executives' activities. Ombudsman we find in Sweden's constitution of 1809, sorry, 1809. Please mark it. Sweden's constitution of 1809. He had the power to prosecute civil workers, other government officials, including ministers on occasion. Civil affairs presently fall under the purview of Swedish Ombudsman. Okay, that's great. Okay, so this entire Ombudsman procedure is a capacity to reassure residents who fear they have been treated unfairly or through investigation of their complaints, prove that their suspicions are unfounded. Ombudsman is once again a procuracy, but with a different aspect. In case of Ombudsman, it is a reassurance that there is a parallel channel to address your grievances. Let's have a recapitulation. First, we had the common law system, courts, council system, council du roi, council d'état, French. Remember council system, French. What is it? A body. Next, we had procuracy, Russia. What is it? A vigilante system. Now, fourthly, we have Ombudsman, Swedish, 1809, Swedish Constitution. What is it? A parallel channel to address the grievances of ordinary people. A parallel channel to address the grievances of the system. Okay. Administrative procedure, a well-organized procedure in addition to being efficient provides for. Now, this is an important thing. What is an administrative procedure and okay, why is it needed? All this. Now see, an administrative procedure is one in which the entire functioning of administration is regulated, modified. Okay. In administrative procedure, we have different systems. We have hierarchy of officials, superiority, inferiority. We have tribunals. We have specific tribunals and specific matters. Okay. Then we have departments, public departments. In those departments, we have departmental inquiries. We have serving of notice, serving of period, tenure, all this thing. So when we talk about different kinds of legislations, there are definitely first is the supreme legislation. What is the supreme legislation? The legislation which is codified, formulated by the parliament. The parliament codifies, the parliament formulates, and then it sort of, the parliament can. Okay, there is just a small disturbance, class. Please bear with me. Okay. So supreme legislation is one of parliament. Parliament can delegate. Parliament can delegate its powers to others, and thereby we get delegated legislations. Okay, let's come to delegated legislations. Now these delegated legislations have to be controlled. Telling how, you know, first is the parliament will always scrutinize a bill in its parliamentary procedure. What is that? A debate. Okay, negative laying when the bill is rejected, affirmative laying when the bill is adopted, procedural control when the particular bill is taken, when the particular act is given out, some procedural controls are given. The extent to which a particular officer has been officiated and with what extent of powers have been granted has been outlined there. Okay, for judicial control we have judicial review, we have administrative education, adjudication, we have the different acts. For example, in India, we have Right to Information Act, whereby a person can ask for information. Search up, search up. Students, your first assignment is search up for what are the administrative acts in your particular countries, from whatever countries you all are here. Okay, please search up on that. There is one more thing, which is difference between administrative law and constitutional law. Supreme law of the land is constitution. Never confuse, guys. Supreme law of land, constitution. Administrative law is a back seat. Administrative law is a genus, while constitution is the genus. Administrative law is just a species. Okay, state structure, everything outlined in constitution, the entire process comes out in the form of administrative law. Constitution, all departments, but administrative officials subservient to constitution. There I end my lecture for today, class. I have covered all the topics whatsoever needed and necessary. I am giving out the main important topics: history, growth, development of administrative law. I have talked about bias. I have talked about prejudice in administrative law. I have talked about how standard operating procedure of administrative law goes on. We have discussed in details about common law systems, about council systems, about the vigilante system of Russia, which is the procedural system. We have talked about ombudsman system. We have talked about administrative efficiency, tribunals, why are tribunals needed, how is a bill piloted through different stages, how the parliament exercises control, different kinds of legislation, Dicey's rule of law, why was the Donohoe committee against so much granting of power to a particular legislation, what is a modern government, what is an administrative organization, what is an administrative unit. Lastly, which is most important, is constitution versus administrative law. Okay, is it clear? The 4 points which I've discussed at last. Constitution is the genus, administrative law species. Constitutional law is basic law of the land. Guys, you can get MCQ exams as well. Basic law of land, constitution, remember. Administrative standard operating procedure, administrative law. Okay. Lastly, one extra thing I would like to mention, it is that about judicial review we have mentioned, but what is a departmental inquiry? I am mentioning this only because I will be giving out in the exam. I can ask you this in the exam. So departmental inquiry is one process whereby a particular person who has been alleged of a misconduct in the department stands a trial by departmental operative procedures. Is that an administrative law or not? This is my question. You all have to find out. Okay. Thank you so much. Thank you.